Hello, welcome back to Legal Opinions with Clementina. I remain your favorite lawyer, Clementina E. Ukiri, Esquire. Today's topic for discussion is a topic that could affect a whooping 80% of the world's population. The employment relationship or contract between an employer and an employee. The topic is determination of an employment contract. A contract of employment may be determined principally by termination or by dismissal on peculiar facts. Basically, in such contracts, both determination and dismissal may be governed by common law rules, statutes, agreements of the parties, which is the employment contract, and some or all of this. In today's jurisprudence all over the world, as governed by international conventions and labor acts in most countries of the world, an employee cannot be dismissed or terminated unless rules of natural justice or other procedures are observed. And some other fascinating peculiarities are discernible. You see, the words termination and dismissal are often used interchangeably. More particularly, the former, dismissal, as describing both events. From available authorities, such reckless usage does not make for clarity. Stricto sensu, termination and dismissal have different connotation and do not mean the same thing under the law. A termination in law is defined to mean end in time or existence or cessation. And so in the law of contract, termination implies its end in time or existence or cessation of the rights and obligation arising from and under a contract. Dismissal, on the other hand, means send away, particularly from one's employment, to relieve from duty, or to release or discharge from employment. Historically, a dismissal was virtually equated with termination. In a master-servant relationship, a subservient relationship, because the master is entitled to dismiss the servant or terminate his employment at will without notice, since he held the employment at the master's pleasure. Such servants who held office at pleasure was regarded then as also having no rights to be heard before he is removed. Such servant who held offices at pleasure was regarded back then as having no rights to be heard before he is removed from office, because there need not be anything against him to warrant his removal without notice, as he held office durante bene placito. The servant had been subservient with little or no rights at all. The law has shifted much from that old subservient status. The present relationship is more popularly an employer-employee affair in constructive reference to the improved status of the employees. The improved status of an employee in today's world connotes basic rights and obligations derived from domestic and international legal instruments guiding the relationship between employers and employee. For instance, termination on grounds of an employee's participation in union activities, seeking office, or having acted in the capacity of a workers' representative, filing in good faith, of a complaint against the employer involving violation of statutes or race, sex, marital status, religion, political opinion, national extraction or social origin, or absence of work during maternity leave. This is further improvement on the rights of employees, increasingly derogating from the traditional rights of employers to terminate derived from common law. Yes, so it's quite a shift from what it used to be. So, the act of bringing the relationship between an employer and employee to an end is termination. How do you go about this? The law has provided extensively that either making specific reference to the contract of employment, the document that binds parties to their obligations and benefits, or by default of the statute, is that termination is necessarily done by notice. Termination by notice is the very usual one that people are used to. So if you're going to get your employee out for any reason, you can give a notice for the period stated in your contract or by the default provision of the Labor Act. Let's say 1 month, to say your services will no longer be required 1 month from now. In the absence of a notice of termination, payment in lieu of notice. This is actually a contractual arrangement by parties that, assuming you are unable to give me notice for any reason, you pay me XYZ in lieu of notice. Reasonable notice. The right of parties to a contract of employment to terminate it by notice where no contrary intention exists is very fundamental. It is very fundamental to the determination of the relationship that is ending and the interpretation of the obligations and responsibilities to either party in such a relationship. The right to be entitled to notice in the case of termination is very fundamental under the law, because this benefit attached to termination is not only provided for by the Labor Act, but these are provisions of international conventions that are binding under our labor jurisprudence. Then we have notice under statutes. This is what the law has provided, that for an occupier of certain position, when you want to bring the contract to a close, this is the period of time you give notice, and you must give notice in this vein. Resignation. Now, resignation is a mode to which an employee brings to an end an employment relationship, which is essentially a notice given by an employee to an employer to say, after this period of time, my employment ends with the organization. There is also termination by lapse of time. For example, when an employment relationship has a fixed term, to say this is a contract employment for a period of 5 years, and after that, bye-bye. Then by lapse of time, termination by the operation of law. This is when, by the death of an employee, what happens to an employment relationship? Gone. In the case of a company liquidation, what happens? Bankruptcy. What happens? So that is also another form of bringing an employment relationship to an end. A subsequent agreement. Yes, there is an employment contract between parties that doesn't state the nature of bringing the contract to an end. However, when parties come together to revise the agreement, to say, let us have an agreement that specifies how we can bring this to an end, then by that subsequent agreement, yes, parties can pull out from the contract by repudiation. Repudiation is terminating by either of the parties a contract of employment before it is due to terminate ordinarily. Repudiation may be lawful and justified, or wrongful and unjustified. This may be waived Waiver here implies condoning the act constituting repudiation. For example, if in an employment there are conditions to say that you must work 5 days a week, right? And then the employee shows up 4 days a week for a period of 1 month. You have breached the fundamental terms or terms of the contract, and as such, I am pulling out from the contract. That is repudiation. Repudiation means because you have done something wrong, because you've breached the term of the contract, I am no longer interested in this relationship. Repudiation. It cuts down the lifespan of the relationship on the basis of a breach from the other side. Now, redundancy. This is when companies are unable to carry the load of employment, the load of workforce. The workforce has exceeded the need for it. So there will be a need to cut down on employees to save resources, layoffs, mass layoffs, right? So now termination by transfer of business. So employment is not transferable unless with the consent of the employee. For those whose contract of employment is regulated by the Labour Act, Section 10 of the Labour Act makes any such transfer of employment subject to the consent of the worker and endorsement of the transfer by an authorized labour officer. Now, a dismissal. A dismissal in contemporary Nigerian jurisprudence should be used as distinct from termination. In contracts of employment, it refers to the special cases of discipline for repudiation by the employee. The concept espouses power, originally and ostensibly extant common law power, exercisable by the employer only, usually as a disciplinary action. It is still distinctively called summary dismissal, in apparent reference to the summary nature of its procedure that marks it off from other detailed procedures of determining a contract, which is peculiar to contract of employment. In the Court of Appeal case of Abomeli and NRC, the Court of Appeal said that to entitle an employer to so treat a contract of employment as at an end of course, there must be a deliberate fundamental breach of a provision of the contract or the employee's duty to the employer. It follows, therefore, that the motive is relevant and the reasons for which an employer abruptly brings a contract of employment to an end must be stated and justifiable. This is the position of the Court of Appeal in the case of Abomeli and NRC. Stay tuned for more nuggets on labor law, employer and employee relationship, employment contracts, breach, and remedies available to either party in such circumstances. Bye for now. Until later.